I argue that it is the most important case about democracy that the court is hearing this term. And I say that knowing full well that they have to decide whether the orange criminal man can run again and if he's immune from everything, including SEAL team. Like, I understand that we have big Trump cases up, but in terms of like how our country functions, this is the biggest case this term. This is the biggest case in 10 years. And it's going to function poorly.
Yeah, I hope that most people in our audience, when we say the Chevron deference doctrine, know what it is, because I've tried to be relentless about this, because it really has been something that has been coming since really Donald Trump's election and the potential for conservatives to take over. And you do a great job in walking through the history of this, because it's there's a sort of an interesting irony about how this came about, because it's contrary to maybe sort of the political or the sort of like the policy decisions that those of us on the left would have wanted brought this about. But it's also, I think, important to put into context when this happened and how much Chevron has shaped really the modern U.S. administrative state in some ways.
Look, Republicans used to love Chevron deference. It was their idea. Okay, so let's go all the way back to 1984. Ronald Reagan in charge, fire and air traffic control people, just saying no to regulation, right? And so he puts in a bunch of people in the executive agencies. We call it the administrative state now, but into the cabinet level of positions. He puts in a lot of people who don't want those institutions to succeed. They want them to fail, right? And one of those people is a woman named Anne M. Gorsuch, yes, mother of current Supreme Court Justice Neil Gorsuch. Reagan puts her into the EPA, the Environmental Protection Agency, with the remit to basically destroy it from the inside out, right? So one of the things she does is that she changes a rule. The Clean Air Act said that in order to pollute the air, you had to get a permit and whatever. And Ann Gorsuch said, yeah, we're not going to do that. We're going to have this special rule so that some people can pollute the air without needing a permit, right? So she gets sued. She gets sued as the head of the EPA by environmental groups, saying that she is applying the Clean Air Act incorrectly, right, against the will of Congress. This goes up to the Supreme Court, and in a unanimous decision, I'll say that again, a unanimous Supreme Court decision, it says, no, the experts at the executive agencies are the people who are allowed to interpret the rules of Congress, right? And that, unfortunately for me as a liberal and an environmentalist in 1984, although in 1984 I was like, 6? Unfortunately for the future, that makes sense. Because, of course, when Congress passes a law, there are going to be gaps. There's going to be ambiguity. Congress, if y'all have been paying attention, ain't always on the ball, right? They don't always know exactly what they're doing, right? So we're going to have interpretation. And what the Chevron case was in 1984, it said that the executive agencies get to make these close calls as opposed to judges. And so for a long time, conservatives loved it. Why, Sam? Because they were sure that they had a better chance of keeping control of the White House and the executive agencies, Reagan, Bush 2, right? As opposed to taking control of the Supreme Court, which from the perspective of 1984 was kind of a liberally captured institution. You fast forward 40 years, and that's why Republicans have changed. That's why they've flip-flopped. They now understand that it's easier for them to take anti-democratic control over the Supreme Court than it is to win presidential elections with orange crazy people.
And we should say there's a couple of things, too, that I want to point out here. I mean, Congress's sort of like hijinks aside, it really is a hard thing for a body of 435 people to come up with the answer as to like how much mercury in the air if it is fired at a certain temperature, is unhealthy for people to inhale. Like, these are questions that are best left to the experts.
I mean, think about it. I like to go through the environmental issue because I think it's the most pressing one in our country, right? But like, think about the FAA, right? Like, how is Congress the right people to decide exactly how many nuts and bolts have to be on the plane before it can fly? No, that's the Federal Aeronautics Aviation Administration that needs to be making that decision. Think about the SEC, right? We can make all the banking laws that we want, but at some point, it's an SEC expert that has to figure out how to apply those banking laws to a banking industry that's always going to be trying to find their different ways around them, right? Think about the FDA, right? Think about the FDA having just come out of the COVID pandemic. Like, who is best placed to decide what drugs and medications and vaccines are available for market? Do we want Congress to decide? Do we really think that like Ted Cruz is the person that needs to be deciding what vaccines were allowed, or do we want experts at the FDA to do it? That's why, for the most part, liberals this entire time, even when Chevron deference's case go against us, for the most part, liberals support this idea of letting experts decide, of letting facts decide, as opposed to judges.
Well, I'm also less concerned about, I mean, look, Ted Cruz decides at one point or another, there is going to be a political influence on these agencies to some degree, right? I mean, because, that's what the original Chevron case was about. And it really seems to me to be a question of, do we want judges making these assessments over, the body politic as filtered through experts? But here's the other thing that I think is like sort of also hard to sort of like see on its face is that in 1984, we're 12 years out from 14 years out. I mean, this case starts actually before than 84. It's resolved in 84. We're only 12 years out or so from the actual existence of the EPA. Like the 60s and the 70s was really the growth of the administrative state in the way that we know it now, the regulatory state where things were modernized. And there was not the same sort of like capacity for legal challenge on these things that we see going into the 80s, into the 90s. I mean, I went to, I was a little older than in 1984, sadly to say. But when I went to law school in 1990, there was something like 40,000 lawyers graduating a year, as opposed to like when my father went to law school in the early 60s, where there's 10,000 graduating a year. Now, the U.S. population had not grown by 4 times in that point. But their corporations in the 70s began their assault on the regulatory state. And it started to culminate at this time. And the Chevron Doctrine became hugely important as a mechanism to allow our administrative state to just function, because Congress can't go back every time that there's a new thing and address it with the speed that a lot of these agencies can.
And frankly, neither can the courts. I mean, this actually came up during oral arguments where Elizabeth Prelogar, the Solicitor General of the United States, defending Chevron deference, talked openly about how simply impractical it was to take this away and expect judges and state court judges, federal judges, and all of these different jurisdictions to make up these rules as they go along. She said that in addition to being impractical, it would also create various conflicting rulings at all levels of our system. Ketanji Brown Jackson said that it would be impractical and chaotic to take this away because, as you point out, Sam, we are a litigious people, right? We are a nacho-eating, football-loving, litigious people. And what's going to happen without Chevron deference is that every time you see a regulation that you don't like, instead of dealing with the experts, you run to court and you try to get a favorable judge to basically overturn the executive decision and start an entire legal battle. Another thing that came up during the case was that since 1984, there have been over 17,000 cases decided under the Chevron deference rule. If you take it out, you potentially not only open yourself up to all this new litigation going forward, you also potentially open yourself up to relitigating those 17,000 cases, because in each one of those cases, somebody lost, right? Usually a corporation, usually somebody who doesn't like regulation, somebody lost, and they will have an opportunity potentially to relitigate that and sue. So you're talking about an entirely chaotic system, but you're also talking about the system that Republicans want, the system that conservatives want. And we can't talk about this without understanding why Republicans and conservatives and people like Neil Gorsuch would do this when it's so obviously impractical and, as Jackson said, chaotic. And the reason is because in a kind of chaotic, impractical, ridiculous system, there is no regulation, right?
Exactly.
Because when you can't enforce a regulation from Congress, when you don't have the executive agencies able to make those decisions, what you end up with is a de facto deregulatory system, because the system cannot handle the influx of litigation and conflict and lawsuits.
Well, what do you say to, and I know the answer to this, but there are going to be people that say, well, when the Republican wins the presidency, when Trump wins, he stacks the administrative state with a bunch of cronies and a bunch of horrible people. Scott, what was his last name for the EPA? The guy that Pruitt. Scott Pruitt, who worked his whole career to dismantle and sue the EPA, becomes the head of it. Some people may say, well, hey, it could be kind of a wash. We know that that's not the case based on what you lay out. But what's the counter argument to that claim made by people?
Democracy, baby. Yeah. I mean, that's what the presidents being able to change executive policy is part of the reason why we have a democracy. Again, Emma, your point came up during oral arguments where Brett Kavanaugh essentially made your point, the point that you're surfacing, right? They're like, every 4 or 8 years, the law changes wildly. That's not good. And again, it fell to Justice Jackson to be like, that's democracy, Brett. That's what happens. And that's why I say this is one of the most important cases about democracy over this century, right? Because it is critical that I, as a voter, have an opportunity to change some of these laws, to change some of these executive rulings that perhaps I don't like, right? I want to be able to vote for a president who might be able to change how the SEC operates, right? Who might be able to change the DOJ antitrust division to actually do, right? I want to be able to vote for that. And if you take the power away from the executive agencies, you're not giving it to Congress. This is the point that's critical, right? You're not giving the power back to Congress because, as we've discussed, Congress is not going to make all of these rules. You're giving the power to judges who I don't get to vote for. Right?
I think that's also, I think that's exactly the point. And it's not just a question. I mean, obviously it's one of democracy, but it's also one of capacity, because under the non-Chevron deference regime, the agency doesn't have, there's one group of people who want the agency to do nothing, and there's another group of people who want the agency to do things.
Right.
Like the Environmental Protection Agency. And they want them to proactively and actively do things. It diminishes the capacity of these agencies to do things and only allows them to not do things, essentially, right? I mean, that's ultimately the point. We had suits against Scott Pruitt where the EPA was not doing what it was supposed to do. Some of those suits won, some of those suits lost. But the agency will be inhibited from what it can do on those years where there is an administration that wants them to do those things. And you can always even slow down. And in the opposite, like evening it out, Scott Pruitt go in there and just have all the people. Well, I mean, they did this with I think it was the Bureau of Land Use. They just said, okay, we're going to disperse everybody around the country and you're not going to work together anymore. There's a lot of different ways to destroy an agency, but really only one to make it work. And that is to give it the ability to act.
This is the asymmetrical war that I, as a liberal, progressive, crazy person, am always fighting, right? Because I want government to work. And to make government work, it's like a very complicated Lego construction. You're trying to build a thing in the Millennium Falcon, and Republicans don't want government to work, so all they have to do is smash it, right? You can spend years building your Lego Millennium Falcon. Republican walks by, knocks it off the counter, breaks it into pieces, and says, mission accomplished, and then walks away. And that is what this case is at heart. The Republicans don't need government to work, don't want executive agencies to function. So if they smash them and break them and make them unable to function, that's as good as a win. That is the win. That is the end goal. And it's the asymmetricness of the war. You're trying to, it takes so little effort to break something. It takes so much more effort to make it work. And that's part of the grease on the wheels. Part of making it work is what they're trying to take away in this case.